All right, so I've got 6 o'clock. I am going to get started. This is a document amendment seminar. The concept or the topic for tonight's discussion is building owner support for document amendments. This is a little bit different than the ordinary document amendment seminar I may give. I'm not really intending to discuss or get into the specifics of the logistics of a vote, meaning the requirements for a vote or the manner in which it must take place under the governing documents. What I'm trying to get at with this presentation is how do you get to that co-owner support? So, no document amendment project is going to survive if the co-owners oppose it. And so a big part of this presentation is intended to describe for those on the call the experiences I've had, good and bad, with respect to a document amendment project. I made a number of mistakes in the different projects I've done a lot of things right, but learned a lot about the things that I see are helpful and things that could be detrimental to a document amendment project. So my goal here is to try to take those experiences, distill them into manageable concepts, and then provide them to you. So as you may encounter a document amendment project, you can take these concepts and build them into and take them into consideration as you undergo your own projects now or down the line. I anticipate that some of you who may have gone through a document amendment project may see some of these concepts. Maybe you didn't know it at the time or really sense it at the time, but hopefully some of this, you'll look at it and you'll say, oh yeah, I experienced that, or we were able to avoid that. But what I've done is I've divided this up into basically there's 4 overarching concepts. I've tried to first go over the different factors that affect the need for and the level of involvement from the community. So what are the types of things that may have an effect on the ability or willingness of a community to get engaged and participate in a document amendment vote? And you can see there's basically 5 things that I want to talk about in this area. The type of organization that you have, the type of document that's being amended, the types of provisions that are being amended. Each of those different things can have an impact on how much information needs to be conveyed and the willingness of the community to get involved. In addition to those kind of specific things, you also have a little more amorphous concepts, which are how engaged is the board of directors? The board of directors is a part of the community. How engaged are they in soliciting community support? And then the flip side of that, or sort of the converse of that, the other side of the coin for that concept is how informed is the community? Those that have to vote of the drafting and the voting process. These factors will all have an impact on how the vote goes. I also wanted to get into potential problems in the amendment process, to go over not necessarily pitfalls, but things to be aware of, things that if they are taking place, and sometimes they're taking place by necessity, but they may require a little more attention. They may require a little bit more involvement from the board or the attorney that you're working with, or even the property manager in trying to address those specific issues. So wanted to go over some of the potential problems. And then the opposite side of that is, what are some positive things that a board or those that are working with you on the amendment project, what are some positive things that they can do to try to help you generate community support? And I've really tried to divide that into 2 areas. One is sort of general engagement with the community, like what can a board do? What can the attorneys or the property manager, what can they do to try to engage with that community generally as a part of the overarching process? And then a little more specifically, what can be done in the actual voting process? As you get out the vote, what are some choices that you can make and steps that you can take to try to get the greater engagement and greater community support? And then I wanted to conclude with some overarching, what I called main lessons and takeaways, but just some things that whether they're truisms or they're things that would carry through almost any vote process, I wanted to go over some things that I think really should take place and should be focused on for any amendment project to be successful. All right, so first up, factors that affect a community's involvement. What are some things that can play into how engaged the community must be? First up, and this may be a little bit interesting to you to see this on here, but the type of organization that you are does have an impact on the type, on kind of the attention that you need to give a vote and the level of participation that you can expect from a community. And what I've done is I've broken it down out into really two types of associations. One is the condominium association. The condominium association process is largely determined by statute. If you've gone through an attempt to amend your master deed, it's MCL 59.190. It generally tends to be more efficient than a homeowner association vote, largely because it is so statutory driven. So a lot of the processes are already in place. And also as a part of a condominium association, in many instances, or most instances, somebody living within a condominium is already aware that they're a member of the association. You know, they're aware that they're a co-owner and that they're a part of a condominium in which there is a collective approach. So really with the condominium association, you have a little bit of a head start because you have the statutory framework, the bylaws and the voting process are largely dictated by statute, not entirely, but in large part. And then you've got a base, you have a community that already knows that they're part of this common interest community. And so it tends to be a little bit easier to pursue a vote if you're within a condominium because all those things are already set. It's a little bit different. It's different than a homeowners association. With the homeowners association, Michigan does not have a overarching HOA law. You know, there's no equivalent for HOAs as there is with the Michigan Condominium Act. So the voting process, the amendment process is almost entirely determined by contract. You know, that's going to be determined in the declaration, you know, whether it's considered a declaration of covenants and conditions, declaration of covenants and restrictions, or just referred to as deed restrictions. You know, that document is going to really kind of form the source of the authority to go through an amendment process. That and then the association bylaws that would guide how the association itself functions. So you won't really be able to look to statute. You'll be able to look to the Michigan Nonprofit Corporation Act for some elements procedurally, but at least with respect to how the documents are to be amended under the declaration bylaws, that's largely determined by statute. And then within homeowner associations, there's really, I divide them up, or at least I think of them as there's really three types of associations in Michigan that I encounter. One is what I refer to as, I'll call it the maintenance association. The other is an enforcement association. And the last is what I consider the modern HOA association, which kind of came about as a response, at least as I see it, as a response to the condominium associations. And the modern HOA association is probably the most equivalent to a condominium association. A maintenance association is, you see these in documents that go back to the 50s, 60s, and sometimes in the 70s. These are associations that were formed for specific purposes. Maybe they're to maintain a lake. Maybe they're in existence solely to maintain a park or a common area or the roads, but they're very focused in what they can do. And these tend to be the most difficult to deal with, at least with respect to an amendment process, because at the time these documents were put together, the concept of an amendment really wasn't around. And so sometimes it requires 100% of the lot owners to get engaged. And sometimes maintenance associations don't even have a mandatory association. So if you're dealing with a maintenance association without an amendment provision, or even without a requiring mandatory membership in a corporation, then that can pose difficulties if you try to update those documents. An enforcement association is a little bit better. So you tend to see these in the 70s and the early 80s. In these types of documents, you have an association that is formed. Almost everybody is required to be a part of the association. And the main function of the association is to enforce a set of building and use restrictions, and sometimes to maintain the common areas. The difficulty that we tend to see with these are that the amendment provisions may be higher. You know, they may be 75%, they may be 80%, but they tend to be higher. And also the treatment of the association is just different than the modern day HOAs. In general, there isn't an attorney fee provision. And so a lot of times from an enforcement standpoint, the associations are left with the choice of either telling people to stop or filing a lawsuit with nothing in between. In some cases, there's no fine mechanism and it's very difficult to bake that in. So the different type of association that you have a lot of times can have an effect on how engaged you must go to the community and really how the community sees the role of the association. And I put on here the different types of memberships because some communities with voluntary memberships, it would be difficult to figure out how to amend them. Who is a member, who's paying, who's not. And in a lot of instances, the community itself may not be aware of the nature of their corporation. So figuring that out is pretty important as you try to set the tone and you set a path forward for going through an amendment project. And also with HOAs, what tends to happen a little more often than with condominium is a lot of people in the community may not even know that they're a part of an association. In many instances, you'll have a group of people that shoulder the burden of doing everything. You know, they're on the board every single year because no one else steps up. They determine the assessments. They've been around for 20, 30 years. And if you're not engaged and not involved as a co-owner, then you might not even know that you're a part of that association. So when it comes time to do an amendment project and the homeowner board goes to the community, in some instances they may say it may be difficult to get the support because the individuals don't even know that they're a part of it. So the type of organization does play a role in really, I consider it the level of engagement, the level of effort that the board will need to make to try to go into the community and generate support. Another factor is the type of document that's being amended. Up here, you can probably see, at least to me, the main types of documents that could be amended. What I've tried to do is kind of not rank them, but at least give them an estimate of how difficult it would be to amend them. In my experience, the articles of incorporation tend to be the easiest to amend. They're the least controversial. The voting process to get that done is guided by the Nonprofit Corporation Act, and it's almost always a majority of votes cast. So as long as you can get quorum and you have the right time frame in order to conduct the vote, it tends to be easiest to get that done. And the articles of incorporation, themselves are a reflection of the relationship between the corporation and the state of Michigan. So it doesn't always have an effect on the day-to-day business of an owner. And so it tends to be easiest to get those done. The master deed is somewhat interesting to me because the master deed in many instances, it can be, not easy is not the right word, but if done right, the master deed itself is not as controversial as the bylaws. It can, however, become controversial to the members if the maintenance responsibilities, which are usually in Article 4 of the master deed, are being modified. If the more significantly modified the responsibilities are being changed, then the more effort the board and the attorney helping the board will need to put into making sure the community understands why those are taking place. As with, at least with respect to the condominium master deed, the process to amending the master deed is almost entirely dictated by statute, MCL 559.190. As with HOAs, the declaration of covenants and restrictions, this is kind of the HOA equivalent of the master deed and bylaws. That's how I always think about it. This, at least in my experience, this can become controversial if the community perceives that there's too much change, if there's too much going on at one time, because the declaration of covenants and restrictions kind of sets the tone. It's more of a unique document than the master deed, which tends to be common between condominiums. But the declaration, those tend to be a little bit more unique and really set the tone for the character of the community. And so if there's too much going on at one time, then the community may have difficulty with that. And an effort really needs to be put into making sure that the community knows what's going on. In some instances, you'll need to pay attention also, because in order to be able to amend the declaration, you'll need to make sure that there's even an amendment provision. And you'll also need to pay attention to the manner in which it would be amended, meaning can it be done by vote, or some documents have what's called a lot owner signature requirement, which can kind of complicate matters. If there's a lot owner signature requirement, you then have to affirmatively go to owners and get them to physically sign the document, which again can ramp up the level of engagement that you need to have. The condominium bylaws, at least in my experience, tend to be the most controversial of all documents. And if you are making considerable changes to the condominium bylaws, then you really need to map out what you want to do. It takes significant planning. The voting process, as with the master deed, is largely dictated by statute, but the concepts within the condominium bylaws are really what get to the day-to-day life of a co-owner. They deal with insurance, board power as between the board itself and the association, assessments, building restrictions and use restrictions. These are all concepts that tend to be included within the condominium bylaws. And so as you go through the amendment process and touch upon those areas, you just need to give some thought as to how you're going to go through that amendment project if you're touching upon the condominium bylaws. Association bylaws, I have this here because there really is a difference between condominium bylaws and association bylaws. Association bylaws are those aspects of, they tend to be included in condominium bylaws at the end. With an HOA, with a homeowners association, they tend to be independent. What association bylaws deal with is really the relationship between me as a member of a corporation and the corporation itself, member meetings, a voting process, the number of directors. These should be, in general, relatively not controversial. And they should be relatively easy to get amended because in most instances, what you're trying to do is to improve the efficiency of the corporation and make it easier for people to participate. However, there is a trap in this concept. In a number of instances, what I've seen over time is that a lot of boards have used, and especially in HOAs, have used their association bylaws to try to bake in concepts that really should be included in the declaration. You know, whether it's rental restrictions or whether it's an increase in assessments, imposing fines, or the ability to lien. Some communities try to tuck into their association bylaws concepts that under the court case of Conlon versus Upton, which is cited here, really need to be decided in a recorded document. And so it ends up getting themselves in trouble. But in general, as long as that's been avoided, the association bylaws should be relatively, not easy, I hate to use that term because nothing is really easy, but not controversial in getting amended because you're usually pursuing, you need a vote of the members and you're trying to increase efficiency of the corporation, something that most people would get on board with, subject to some exceptions I'll get into a little bit. Lastly, I included rules and regulations here really as a catch-all, because if you as a board or a property manager assisting a board are thinking about an amendment, one thing to think about first is the thing that I'm trying to achieve, is the thing I'm trying to do, can I achieve that through the adoption of a rule or a regulation or a policy? Is it something that the board has the power to do independently of a co-owner vote? Because if you can do that, if you can accomplish what you want to do by rule, then that makes at least the decision-making process a lot easier because the board would be able to adopt that unilaterally. Now, there are limitations on that though. Under that same case, Conlon versus Upton, the adoption of a rule or regulation needs to be limited to a concept that is either interpreting or implementing something that already exists in the governing documents, in the recorded governing documents. So rules and regulations can be an effective way to not go through the amendment process, but it needs to be approached carefully. So, and the reason I have these here is depending upon what you want to do, if you're simply amending the articles of incorporation and association bylaws, hey, that may be easier, and you may not need to give the level of involvement and attention that a overhaul of the master deed might require. Another thing that is significant in determining how much explanation needs to be given to the community and how to get their support are the types of provisions that are being amended. To me, at least, I divide these up into three categories. To me, these are kind of the three things that are most significant, or at least are felt most by the co-owners. And I divide these up into one, money. So does it affect the owner's wallet? Kind of power is another way to phrase the second one, but do the changes affect the owner's relationship to the association? And the last one is, do the proposed changes or the amendments affect the owner's ability to use their own home? You know, and this tends to be in the building and use restrictions. So it's really those three categories. Does it affect the owner's wallet? Does it affect their relationship to the association? And does it affect the ability to use their home? If you're touching upon one of those three areas, at least to me, you need to be giving considerable thought to the the process that you're undergoing. With respect to the wallet, so this is probably the one that is objectively most significant to people, because you're actually dealing with the cost to them to live there. You're dealing with the expenses that they incur. And as you make choices in this area to benefit the association as a whole, or individual co-owners, if you're shifting things that way, you do need to give thought to what sort of impact this is having on people. And I tend to view this in three categories. One is if you're shifting maintenance responsibilities. So say the association has a large amount of maintenance responsibility that in certain instances may be properly allocated to co-owners in certain instances. If that's occurring, and if co-owners are going to have more of a responsibility, then that should be explained so that they understand why that's happening. If there's little explanation or little understanding as to why that's occurring, then that may not be received very well. And similar to that is the concept of insurance responsibilities. If your documents provide for insurance responsibilities, either at the association, on the association's behalf, or at the co-owner level, then if there are shifts one way or the other, that should be explained to co-owners so they understand what's happening. And at least in my experience, that's most significant with, I'll call them attached condominiums. These tend to be townhouses or apartment style or lofts even, where the association bears a significant responsibility. So in those instances, if there is an allocation, co-owners come into that scenario with expectations. And if those expectations are being changed or shifted, then you can expect a need to be able to explain that. And lastly is increasing assessments. If you're outright altering the assessments that a co-owner will need to pay or an owner will need to pay, then that needs to be explained. This tends to be a significant, this doesn't tend to be an issue for condominiums as much, because with condominiums, the assessment power is largely dictated by statute, and most condominium bylaw provisions tend to be very similar, if not the same, as you look at your assessment power of the board. But with respect to HOAs, this does tend to be an issue, especially as you look at the older maintenance associations or enforcement associations. In some instances, those communities have outright caps on what the association can impose on a yearly basis. And sometimes those caps do not match up with the association's expected expenses in a given year. And so if that's the case, if the association is looking to pursue an increase in the authority to impose assessments, then you can expect that from the community standpoint, there's going to be a need to plan it out and again, increase the level of engagement. This one to me is potentially the most interesting. The dollar, affecting somebody's wallet is somewhat self-explanatory. I mean, if it's going to increase costs or have an increase in costs, people are going to want to know about it. But this one is a little bit sneaky, at least to me. So you've got basically a couple different areas where people will want to know what is being altered in the relationship between the individual co-owner or owner and the association itself. Again, with expectations, individuals have expectations about that interplay and their role within that association. And so if the amendments are proposing to alter that in some way, or if they're perceived as altering it, then the board should be prepared for a possible need to be able to explain that. And at least in my experience, that tends to be in three areas. In one, we tend to recommend certain limitation and liability provisions for associations in order to minimize the exposure for the association collectively, with the goal being to reduce the insurance premiums of the association over time and decrease the overall cost of administering a condominium. But in many communities, that may not be received in that light. And so if there is a limitation of liability provision that is new, either for board members or for the association, and so that the board should be prepared to be able to explain that and understand that. So that's one area where we've seen owners tend to want to know why is this here and what's going on with it. Another category in this sort of concept is if there's a perceived expansion of board power especially if it's seen as an expansion of board power at the expense of, I'll call it the people, but the individual owners. And I tend to see this happening in 4 areas. Again, we recommend, coming out of the COVID pandemic, a certain emergency powers provisions. But the presence of those emergency powers provisions, if individuals are reluctant or skeptical of an exercise of authority by a board, may be viewed in a light that would require additional explanation. In 2 other categories, I put these here because they're board power, but they also deal with finances and money. Is it if your documents require co-owner approval for borrowing funds, if that's being altered, co-owners may want to know why or have a question. And not necessarily about the current board, but in some instances, they're not thinking about the board, which is in power at the time, which maybe has the best, is the most altruistic in everybody's goodwill at heart, but the board down the line that maybe people don't know about. And along the lines of eliminating the owner requirement for borrowing funds is special assessments. If you're altering or increasing the flexibility given to the board of directors to impose special assessments, then depending upon what you're trying to do and how the community has experienced that in the past, you should be prepared for that to have a possible impact. And then lastly, in this category is increased rulemaking authority. If you're giving the board outright more power to do certain things, or at least if it's perceived as though you're doing that, you should be prepared to explain that, and that may trigger a little bit more engagement with the community. And then lastly, these tend to be efficiency concepts, but again, we have seen communities where this has been an issue. Sometimes it surprises me, but not always. And the 3 areas that I tend to see this are: 1, reducing quorum provisions. Some communities have difficulty meeting quorum, but some individuals don't want decisions to be made by a majority of a smaller quorum. And so if you are reducing quorum, just be prepared for that type of question. And then on meetings. So this is a remote meeting, but some individuals like remote meetings and some individuals like in-person meetings. We actually have had some communities where individuals have not wanted to even allow remote meetings. And so this is a concept that, at least in some capacity, you should be prepared to explain if there are provisions for this in your documents. Somewhat ironically, though, especially if you've worked with me on document amendment projects, the Nonprofit Corporation Act already allows this to happen as long as your documents don't prohibit it. So even over somebody's objection, as long as it's not prohibited, it can already take place. And lastly, this one is less common, but if you're reducing the voting threshold for certain documents, say in a declaration, you're going from 75% to 66 2/3%, sometimes the individuals may see that as, again, shifting power to the board and taking power away from the members. So if there are issues that could be perceived as changing the relationship of the individual as between themselves and the association, that's just something to think about and take into account as you plan things out. And lastly, so the other one was sneaky. The first one, dollars, is, money is important to everybody. Dollars are important to everybody, and expenses are important, so you should expect that. This one tends to be probably the most controversial and emotional. So what we're dealing with here is if you are amending or you're changing the very things that people can do within their own home, either with respect to building restrictions or with respect to use restrictions, then you need to be prepared for the community to ask questions and need to understand why, especially if what you're proposing to do is a deviation from what's been done in the past, or if there's been prior boards or a historical lack of prior enforcement in the community. If the documents have not been previously enforced and you're now undertaking an effort to amend them, it may be difficult to get that community back to square one. And it also goes with architectural control. Communities like to see uniform enforcement. And so if you have a deviation from historical conduct, that could pose an issue. I had a couple things in there that sometimes unexpectedly become issues. So you just need to be aware, if you're imposing new solar panel restrictions or electric vehicle restrictions, just be prepared to explain why they're taking place. These tend to not be controversial. I think people understand the significance of them and the benefit to the community if there is a level of restriction, but at least just be prepared to address those. Those have kind of snuck up in some cases. And then with respect to use restrictions, I've at least highlighted the 5 that in my experience tend to be felt the most by individuals within the community. And so again, if there are changes, they need to be thought out, and at least with respect to how to explain in the community. And they tend to be rental amendments, vehicle usage and parking, pet restrictions, home offices, and then signs and flags. Among these, rental amendments, if they're being done, tend to be the most impactful. If there is already a division within the community as to who wants certain rental restrictions or prohibitions and who doesn't. But the point of this particular slide is if you're going through an amendment project that touches on these areas in significant ways, then you should be prepared to need to go into explaining to the community why these are happening. And then the last 2 concepts in this category is what is the level of engagement of the board of directors itself in trying to garner community support. It is the case, to me at least, that the board really is in the best position, at least initially, to gauge and evaluate the sensibilities of the community. They have the most interaction with administering the condominium. They have the most experience, at least on an overarching generalized basis, with the documentation and the governing documents, and are generally in the best position to make recommendations to benefit the community as a whole. So it really is important for the board to be involved in an amendment project, and both with respect to decision-making, evaluation, and then also interaction with the community. But even though they're in the best position, that doesn't mean they always get it right. So one of the things that a board, at least in my mind, should endeavor to do is as they go through an amendment project, because of their unique position, the amendment project itself, the goal should be, at least in my mind, to preserve the character of the community and be aware of the impact of the amendment on the individual owner. So it's a little bit like, don't forget there are trees as you manage that forest, but there are individuals, and at least be aware of, if you're doing something, understand the impact that it will have on the individual person. So and the purpose for this is to say, hey, the role of the board is incredibly important in trying to generate community support. And along these lines, with the board being in its position, owners will look to the board for guidance as to how to receive those documents. And in order to be able to convey that information, in order to be able to convey that confidence, the board must understand both the reason behind the amendment. Why are we doing this? And why are we approaching this? Why is it important enough that we're willing to sink the time, energy, and money into this amendment project as a generalized concept? But then they also must understand the document itself. That becomes a little bit more difficult with an amended and restated document, but they should understand the document as drafted so that if asked about different concepts, they've at least reviewed it and can understand the document that they're asking everybody else to weigh in on and approve. And then lastly, in this category, one question would be, what has the board done to reach out to the community regarding the amendment process? This is probably a relatively difficult thing to approach, because it does take some advanced planning. I tend to think of it in 3 distinct stages. First, there's a pre-drafting stage, which is the community trying to figure out what they want to do. What type of amendments are appropriate for us? What can we achieve? Then there's the drafting stage. As we put this thing together, how many voices are going to be involved in trying to put it together? And then in voting, how engaged is the board and the community in getting the voting out? And there are pros and cons to the different levels of involvement. The more involved the community is, frankly, less likely it is that you'll have a cohesive document, because you'll have so many voices. You end up with kind of too many cooks in the kitchen concept. But if the board is very reserved and keeps to itself all of the decision making, And as the board goes out into the world and asks people for support, it becomes difficult to generate that support because the individuals who you're asking to vote may not have been involved. Ultimately, on this issue, communication, the way I phrase it, communication can make or break an amendment project, but that goes both ways. Too much communication can sometimes drown everybody in information, or at least get too many people involved, but not enough communication can also be problematic from the board's perspective. The flip side of that concept, as a part of the question of determining how engaged must the board be, there's the ultimate question, which is how informed is the community of the drafting and voting process? And I tend to think of this as three different things. So first up, as we embark on a vote process, so as we go through the voting and we're asking people to vote, one thing that will help drive the success or failure of the voting project is, does the community as a whole itself understand the benefit of the proposed amendment? Is the amendment perceived as benefiting the entire community or a select few? Ultimately, if it's viewed as a pet project, if it's viewed as something that is simply benefiting a minor group of people, then it will be difficult to be able to convince the entire membership of the reason to vote in favor of it. And the corollary to that is, if you have outdated documents, if the Nonprofit Act and if the different laws that have been passed over the years have passed your community by, and if the risks of your documents are pretty significant, and if that's the reason that you're pursuing an amendment project, does the community understand those risks? Do they understand the need for the amendment? Not necessarily the benefits that you're going to be getting. I mean, that's a part of it, but do they understand the risks and what the association will face if the proposed amendment doesn't pass? It's very similar to understanding the benefits, but it's a slightly different perspective. And then lastly, does the community understand the voting process itself? Do they understand what's happening, what they're being asked to do? If the community is confused about it, if they don't understand what the actual process is, then they may feel disengaged. And the way that I kind of view it is, it may chill their willingness to support the amendment and get involved. If they don't understand what's happening and what they're being asked to do, it just tends to deflate or kind of chill the community as a generality, their ability to and willingness to participate. With respect to, so those are kind of the factors that I see that are generally important in determining the level of engagement that you need to have and how important it's going to be to put effort into generating community support. Just to kind of recap them, to go over the ones that I went through, you've got the type of organization that plays a role. You've got the type of document that's being amended. You've got the type of provision that's being changed, the level of engagement of the board, and then the level of knowledge and community knowledge of the actual amendment process. So what are some potential problems? Assuming you've taken all those factors into account, what are some ways that the amendment project can still be tanked? So you've taken everything into account, but what can go wrong? So these are just some factors. I'm not going to get into them in too much detail, but these are some things that can have a negative or adverse impact on the ask. As the board goes out and asks for somebody's vote, these can have a negative effect. One is if there is a distrust of the board for other issues. And at least in my experience, this in a lot of it, not every time, but in a lot of instances, tends to flow out about concerns about fiscal management. Maybe there are concerns about the budget. Assessments have gone up over years past. But in some instances, if there's a general distrust of the board by certain individuals or groups, then that may negatively impact that group's willingness to listen to the board as the board then makes a pitch to the community about the need for the amendments, even if the amendments otherwise are completely necessary and benign and of complete benefit. But a distrust of the board can have a negative impact. And then kind of coming out of the factors, these next couple probably are natural conclusions to some of the things I've already gone over. But if the board has not had any level of engagement with the community during the drafting and voting process, then to a certain extent, what goes into it comes out of it. And if there has been a lack of engagement, then it may be difficult to generate the support necessary because the community may not fully understand what's going on. And along those lines, if the community doesn't understand the benefit to why they're doing it, then there may not be an incentive, and there wouldn't be an incentive for them to participate in the voting process. So engagement and the understanding of the benefit are two things that are pretty important. The next two kind of go together. If you are having a project that includes what I characterized as an emotionally charged topic, and this is going to, at least to me, be within the realm of rental amendments, pet restrictions, those types of things that affect what you can or cannot do within your unit. Those types of things, they can be, not always, but they can be very important to people, and people in communities, if the amendments have a significant effect on those individuals, it can create an emotionally charged situation that can drive the amendments in a certain direction. So it's important not to go a certain way, but as the board moves forward with the amendment project, that you be aware of the community sensibilities on these particular areas, so that if you choose to go forward with something in this realm, that you at least understand how it would be received and be in a position to explain it, and at least identify with the concerns that are being addressed or being vocalized. And along those lines, because this is a category of potential problems, if there is a significant vocal opposition to an amendment, then that may have a negative impact. It does tend to be the case that those who are most opposed to an amendment tend to be the most vocal. Those who are in support of it tend to express their support quietly through an affirmative vote, and those who are opposed to it tend to express, these are generalities that are not always true, but tend to understand or at least see the significance of communicating their opposition. And so there can be instances where you'll have significant vocal opposition, which you should be prepared for. And if you've had a significant level of engagement already with the community, and if the community as a whole understands the benefits to what's happening, then that vocal opposition should be minimized or lessened, because ideally they would have been brought over into the camp of supporters. And then lastly, this category is a little bit of an anomaly, but it can pose significant problems. You live within a community, and it would be great if you were the only decision makers within that community, but a lot of documents contain provisions that require a developer municipal consent. So even despite your best efforts, if your documents do contain those provisions, they may pose hurdles for you as you try to get the amendment completed, but you aren't able to achieve that last aspect. All right, so that was sort of the doom and gloom aspect. And I've tried to go through the factors that you should take into account. The next category of things are, what can you do? Look at these happy people. They're super excited about the positivity going on in their community. But what can you do in order to try to drum up that community support? All right, so a couple things. First, you need to give it some thought to the following factors. What is the scope of the amendment project? Is it big? Is it small? Is it focused? Is it all-encompassing? An all-encompassing project, as you can probably imagine, is going to require a lot more level of attention. And then you've got the complexity of the amendment or the amendment process. If all you're doing is increasing the number of board members from 3 to 5, you might not need a whole lot of explanation. But if you have a lot going on, or your amendment process is multiple stages, then that level of complexity will probably mean that you're going to need to have a little bit more engagement with the community. And then going back to some of the issues that I've already touched upon, if the proposed amendments are going to have a direct effect on the owner's wallet, their relationship with the association, or their ability to use their home, you'll need to give some thought to and planning to how to engage the community. Not necessarily always before the drafting stage, but at least prior to the voting stage, you should give some thought to it. So what can you do? What are some things that can be done by the community in a general sense to try to get that community involvement so that the community understands or feels that their voice has been heard in trying to be a part of determining what goes into the governing documents? One is to set the table, to start discussing the potential for amendments at annual meetings or other events, to get it out there, to let people know that this is a topic that's being investigated so that it's not new, to them when the voting takes place. You can use surveys. Surveys can help determine community support. You can do these on specific topics. Rental amendments tend to be the one that is pretty significant, but others as well. You can deal with them in architectural control restrictions, size limitations. surveys can help, because maybe the board views it a certain way, but the board is missing the mark on it, and surveys can help with that. So surveys can be an effective way to determine community support. You can also use owner committees. So a board can create a committee, the purpose of which is to make recommendations to the board itself as to what to change. These can be very helpful because a lot of times you go to the community, you can ask for volunteers. So if individuals are not asking to volunteer to be on that board, then, to a certain extent, it would be difficult for them to have significant opposition to something that they chose to not have any role in. This does have a double-edged sword, though, because as you cede some level of control to committees, that may mean that others with different interests may come into the fold and may end up pushing their own interests. So it's just something to watch out for. But committees can be very helpful sometimes in trying to generate interest in getting engaged with the community. And then lastly, just the different types of getting the information out. Using your website, flyers, if you have a community monthly periodical, using flyers, a message board, a community message board can be helpful, or even email. This is an effort to try to communicate the concept of an amendment project in different ways so that people hear it differently and they understand that it's coming. And then most significantly, all of this ties over into the amendment project itself, is I get 15 pieces of mail a day. And of those 15 pieces of mail, 16 of those mean nothing to me because they're junk mail and they go away. I don't really read them. So one of the important things is to give thought to how are you going to distinguish the amendment project and letting the community know what's coming so they don't take that piece of mail that comes into them and dispose of it like every other piece of routine mail. Not that that's most significant, I guess, but just something to give some thought to. So what the goal of these steps is to try to get into the community's mind, all right, we're doing something that is significant, we're doing something that is important, and we want the community to understand it. All right, so those are sort of general steps. What can you do with the actual voting itself, the documents itself? What can you do with the amendment project itself? And what decision-making can take place in tailoring what you're working on to the needs of the community? At least with respect to some of the decision-making, I broke these out into 3 different possibilities. One is, in some instances, is amended and restated documents versus spot amendments. In some cases, depending upon the age of the community, you're just not going to be able to get around having to do a complete rewrite. But in some instances, if all you want to do is change a handful of things, 3, 4, and I've seen anywhere up to 15 different amendments, you can do what I call spot amendments. You're not doing a complete rewrite of everything, but you're tailoring the changes to specific things. Maybe all you're doing is changing the number of directors. All you're doing is changing quorum, or all you're doing is altering the rental provisions. Those tend to be easier for the community to understand because they can put it in context. The overarching document is not changing, but they can see the thing that is being changed. And so in some cases, a spot amendment can be helpful in trying to let the community know what's happening. In other instances, an amended and restated set needs to be the way to go because of the scope of things that need to be altered. But that's at least a decision the board should make, and consideration the board should make as to amended and restated versus spot amendments. The next concept here is how staged out is your amendment process. At the beginning of this concept or this webinar, I touched on the different types of things that are being amended, the different types of documents. And I talked about the differences between the ease with which sometimes you can get the articles of incorporation and association bylaws passed because they tend to be not controversial, versus not difficulty necessarily, but the attention that you need to give if you're altering some of the things that are more significant that affect people's daily lives. And so, especially for homeowner associations, in some cases, it may be helpful to first get the articles of incorporation and association bylaws out of the way, so those are updated, and then turn to the declaration in order to try to make sure that you get the least controversial items actually passed. In some cases, it makes sense to put those 2 together and to do them all at once, but at least something to give some thought to as you're trying to figure out how to communicate this process to the community. And then lastly, I call this all or nothing or menu style ballots. I tend to avoid menu style ballots unless it's absolutely critical in order to get something passed. And in those instances, it's going to be where something is just so controversial, or we just really have no idea which way that a particular topic is going to go, that we want to separate that out and allow the community to make a choice on that specific thing. Just to give you an example of how that might work, maybe we have a set of amended and restated documents, but we have, we're not sure if a particular provision or revision will be passed or will be necessary. So we may call that out separately. Or in a series of spot amendments, say we have 5 different spot amendments that are being proposed. Maybe we list all 5. Are you in favor of 1, 2, 3, 4, or 5? To create kind of a menu for people to select. That is appropriate in some cases. The difficulty with the menu style option, though, is that that often leads to one of those not passing. Because ultimately, in many instances, owners tend to be comfortable understanding that maybe they're not going to get everything that they want, but as long as it is viewed as a benefit to them as a whole, they will vote in favor of a project. But if they're given a choice, they may be a little bit more picky. And so if you do pursue a menu style ballot, just need to be prepared for at least one or more of those not passing. And now, how about the vote itself? Really this, not last category, but what can you do in the voting itself, in the actual voting process, to generate not just the maximum attention, but to try to get people engaged and get the most amount of people voting either for or against, ideally for, but at least get them voting. So these categories, these are the different things that I use. Some go different ways, but you can kind of see what I tend to do. First, in large instances, or in many instances, I try to get what are called electronic consents, because there's a cost that goes with mailing out a voting project. And so we will usually discuss with the board the significance of getting electronic consents and seeing if it makes sense to try to get consents from co-owners to try to utilize email. Email is an efficient and cost-effective way to communicate. There's no postage for it. There's no copying charges for it. But under the Michigan Nonprofit Corporation Act, email can only be used if somebody opts into it, but it can be effective. So it's one thing to keep in mind as you go through that process. And the next concept goes along with community engagement. To me, it's very important to have informational meetings during the voting process itself. So these are informational meetings after the documents have been sent out. So the individuals have received the documents and they have the ability to review them and ask questions, sometimes difficult questions. And this helps provide explanation to owners, as they've got them in front of them. And in some instances, it can isolate or identify concerns that individuals have. And in some instances, it may have a negative effect on the voting process itself. But the informational meetings to me are invaluable because they're demonstrating a couple things. One, they are providing information to the community, but they're also demonstrating the community itself that the board is willing to get out there and defend, or at least attempt to defend, the documents they're asking everybody to vote on. So to me, informational meetings during the voting process are pretty important. And then logistically, there's also the concept of voting by ballot or voting at meetings. I tend to like to do both. To me, it is important to try to give people the opportunity to vote at a meeting. But if you're only collecting votes at a meeting, then you're not giving the individuals who can't attend those meetings the opportunity to vote. So I tend to try to, at least when possible, provide the opportunity to vote by ballot and by meeting at the meetings themselves. And having that maximum opportunity or maximizing that, to me at least, is increasing the likelihood of a positive vote outcome. You then have remote meetings versus in-person meetings. This is actually a little touchier than you would expect. In most instances, people are comfortable with remote meetings, and we actually have a method that allows people to vote during remote meetings. But there are some communities where people may not be comfortable with technology. They may not be comfortable submitting and voting something by clicking on it through their computer. And in some communities, an in-person meeting may be necessary. So not that it needs to go one way or the other, but as the board figures out the best way to go through the project, they should give thought to what type of meetings are we going to have? Are they only going to be remote? Are they only going to be in person, or will we do hybrids? And then lastly, I'll throw this, I do think of this as kind of a sneaky factor. but is how much time are you giving people to vote? This kind of goes both ways. In my view, I tend to like about 45 to 60 days for a voting window. In my mind, 45 to 60 days gives people the opportunity to digest what they're being asked to vote on. But at the same time, it doesn't put it out so far that it gets backburnered and then not thought about until it's too late. So too short of a window can be too compressed, and owners may feel that they're being rushed into something. But if it's too far out and it's if they're given too much time, then it can lead to a lack of interest or complacency. So these are factors that, to me, go into the voting process itself and decision making, and as to how to conduct the vote in different ways that I think you can maximize that co-owner involvement. All right, so in a more generalized way, the main takeaways that I have, or at least the things that I think are very important, no matter what you choose to do, like as you go through the amendment process, the amendment itself, the thing that is being drafted, the thing that people are being asked to say yes to, that document should reflect the character of the community as it's being updated over time. If the thing that people are being asked to do is a significant departure from that, if it is altering the character of the community, if it's changing community standards, then if the board is going to expect people to vote in favor of that, then the level of engagement must be pretty high, and the community must understand why this is being requested of them. The closer the amendment is to preserving the character of the community as updated, then the easier it will be for the community to understand it and be receptive to it. Along those lines, the board needs to understand the purpose of the amendment. In essence, the board is going to need to, through its actions, whether it's sitting at an informational meeting where an attorney, as I've done, tries to explain the amendments, the board must, though, understand why they're going through this process. Why is the amendment being done? And the community itself should be informed and engaged. If the community doesn't know why this is happening, if the community has not been informed that this is occurring, or if the community just has had no level of participation, then it may be difficult to get them to vote yes. The more informed they are, the more engaged they've been, then it tends to be that the more willing the community is to participate because they're invested in the process. Sometimes you might not like the outcome if the engagement has led them not to like what's happening, but you will at least have their active participation. And then along these lines, transparency in the drafting and voting process is important. And the way I think about this is, as you go to the vote, as you go to the ask, if the very first time that the community is hearing about this is when it's presented to them, and they have no idea how this thing came into being, how it got drafted, who the individuals were that participated in its coming into existence, if that is not known, then it's going to be a little difficult to get that community to say yes. And so the more transparency that is present, it should be easier for the community to understand not just what's been going on, but also to be comfortable with the process itself. And then kind of really touching upon the last couple of slides I covered, choosing the right voting process can help. As you make decisions as to how to conduct a vote, that can help also drive a successful outcome. If you have a ballot-only 10-day voting window with no informational meeting, then it's going to be difficult to get that amendment passed unless it is very simplistic and you have a very small membership. So that's just something to keep in mind. So those are that's the presentation. Those are the concepts that I wanted to go over. Again, this type of presentation was probably a little bit different than what I've done in the past if you've attended other presentations that I've given. But what I wanted to do was to convey those things that I felt were helpful, those pitfalls, those problems that I thought could be exposed depending upon the approach taken, and then different ways to address those. So with that, at least the formal presentation is concluded, but I would love to attempt to answer questions if anybody has any questions.